people. We are here for another Volnay Live. We are excited for our guest tonight. It's Richard Lynds, one of Boston's best zoning attorneys. Here we go. Let's see if we get him on. Mr.
I
Lynds,
figured it out.
how's it going?
Good. How are you?
Good. Thanks for joining us. We'll give a couple another minute here to get people on. But how's the family? How's everybody doing?
Everybody's good. How about you?
Doing pretty good. That was my drink, I swear. No, we're excited to have you. Got a bunch of questions. Got some softballs for you, but we'll see if we can get some more complicated ones. So we got people joining in now. So everybody, as you're joining, you can use either the questions option or in the comments. And I'll try to get to every question at the end of the interview. We've got about 20 that came in throughout the day today. So we'll go through those ones, and then we'll answer as many as the ones that come in as we can. But Rich, thanks for joining us. And kind of, can you just tell us a little bit about yourself, how you got into, into law, but then into the real estate law and zoning specifically?
Sure. Yeah. So thanks for having me. I hope everybody's doing being safe and getting through this. I know it's crazy times, and this is a good opportunity to at least be able to continue to do some outreach and some networking. So I appreciate you putting this together. I've been practicing law for about 22 years now here, mostly in Boston. I started my practice in a small firm on the South Shore when I got out of law school. And I've been pretty much focused on real estate development and permitting. I started my own shop around 2002, downtown Boston, small little practice. And have been pretty much just stayed focused on a smaller scale type firm where I try to focus on client needs that are pretty much in the development industry, mostly throughout the greater Boston area. I sat on the Zoning Board of Appeals in the town of Winthrop for a few years. I was the chairman for about 3 years, so I was able to see a little bit different perspective from zoning, from the perspective of different municipalities. Boston's quite unique, as I think as a lot of people know, in the way that they approach zoning, and they have their own specific zoning code. So it's nice to be able to balance that a little bit and see how it's done elsewhere. I really don't do a lot outside of the Boston area these days. There are a few municipalities I will practice in, but for the most part, I try to stay focused on Boston.
Nice. So for all the newbies on here and someone who's not done a single deal, from a perspective of zoning, kind of run us through, what does that even mean? So what does it mean when a deal requires zoning?
Yeah, so zoning, for those not really familiar with it, is pretty much the rules and regulations that apply to any building, whether you're building from the ground up or modifying an existing building. A lot of times zoning isn't necessarily a consideration if you're buying an existing building and not looking to change much on it. When I say much, by way of expanding the footprint or the interior of the building. Zoning's typically not going to be a concern for your average buyer. But where you are looking to develop a site, whether it's expanding existing structure, taking down an existing structure and rebuilding, or starting from scratch with the ground up, zoning most often will be a consideration. And some of the things that, some of the terms that people will hear is as of right, variance, special permit. All of those are the types of issues that often will come up with the development projects. And specifically, if you're looking to change or modify an existing site, then you probably will have to deal with one of those issues. And typically the way that that we deal with zoning is through what's called a special permit granting authority, or the permit granting authority. In this case, in the city of Boston, it's the Zoning Board of Appeal. The zoning board has the power to grant variances, which are exceptions under the zoning code. Also, you have conditional use permits, which are, for lack of a better term, a special permit in the city of Boston. And the process for that is pretty unique here in the city of Boston. It's not necessarily similar to what we see in other municipalities. It's heavily driven on community process, where you essentially have to bring your project to the neighborhood, have the neighborhood vet that project and give input. And under the current administration with Mayor Walsh and the Boston Planning and Development Agency, Neighborhoods have a lot of say and a lot of input in projects and what's going to happen in their particular neighborhood. So finding a balance as to what works for the developer as well as what works for a neighborhood sometimes is the key to a successful project.
So I'm a client and I decide I want to do a project that's going to require some type of variance. Kind of run someone through the steps that would go there and how that process starts. And,
Sure.
and kind of just so before we get into the nitty gritty, but just run through the journey of a zoning project.
Yeah, so typically all projects, and I'll use Boston as the example since it's probably the most relevant. Projects start with the filing of a building permit application in the city of Boston. That is with the inspectional services over at 1010 Mass Ave. If your project conforms to the zoning code for that particular address, then you will likely just proceed to obtaining your building permit, provided you provide the city with all the necessary plans that are required for the issuance of building permits. If your project does not meet the zoning requirements, and that's specified in the Boston zoning code for that particular neighborhood or for the city itself, then you'll get what's called a refusal letter. And the refusal letter identifies what the specific violations are or the issues that are related to the zoning code that you can't comply with. For example, if a building maximum height in a particular neighborhood is 35 feet and you're proposing a building at 40 feet, that would be a zoning violation, and that would require a variance from the height requirements of the code. That will be specified in a letter, at which time you then will take an appeal, and that's a petition to the Zoning Board of Appeal for purposes of requesting the variance or requesting the relief from the code for that particular provision. And that's more or less the administrative paper side of it. The actual process and the mechanics behind what happens next really involves working with the community and working through the community process. Typically, if you have an active civic association in the particular neighborhood you're working in, you may make 2, possibly 3 visits to that association to present your project. The mayor also requires in the city of Boston that you have what's called an abutters meeting, and that gives specific notice to people who live in close proximity to the proposed project, and you have an opportunity to have dialogue and discussions with them as well. At some point, you will ultimately make an appearance before the Zoning Board of Appeal. That's a 7-member board that meets pretty much every other Tuesday, although with the current pandemic, they haven't met since mid-March. They potentially could be meeting in May again, but that remains to be seen. When you appear before the zoning board, you make your presentation, which is pretty much the project that you've either presented to the neighborhood or modified over time. And you need 5 of the 7 members of the zoning board to approve that prior to grant the relief that you're requesting. If not at least 5 of the members of the board vote in favor of the relief you're requesting, your relief will be denied, the request for relief will be denied, and you would not be able to proceed with the project. If you are successful, and there's no guarantee that you will be, in getting 5 of the 7 members to support your project and grant the relief, the board then will prepare a written decision that gets filed with the Inspectional Services Department and becomes part of the permit file. Once that occurs, there's a period of time in which a judicial appeal can be taken. People who oppose or object to the project have a right to seek judicial intervention and appeal your zoning decision, but they have a very limited window in which to do that, and that's 20 days from the time it's filed with Inspectional Services. If that appeal is not taken within that period of time, the zoning relief that's been granted stands, and you would proceed throughout the remainder of the process to obtain your building permit. There are, and again, speaking about Boston, there are some additional steps that occur after zoning approval. One that people hear about often is Boston Planning and Development Agency design review. The city maintains a set of standards for urban design. They have a very talented staff at the BPDA who reviews every project that obtains zoning relief to ensure that they meet those standards, and that includes materials, architecture, and design. When that is completed, you're then able to finalize your permit file and obtain your building permit. I think I covered it all, Ricky, and let me know if I left anything out.
No, yeah, no, that's for sure. When you're looking at the presentations with the different groups, are you presenting the same presentation to the ZBA as you are to the neighborhood, as you are to the abutters, or does that process change, and does it over the time of the presentation, does it change? How does that go?
Yeah, that's that's the give and take that's unique to Boston. Oftentimes a developer that will hire a zoning attorney has a plan for a particular site or a project, and that rarely is the project that gets ultimately presented to the zoning board based upon community input and what drives, essentially what the desires of the neighborhood are. So you may see some changes to that project based upon the community process, and that is based upon input that we hear from neighbors, elected officials, and others who are considered the stakeholders for these particular petitions for relief. When the project starts, we typically tell the neighbor this is the first pass at it, or this is an opportunity to open a dialogue, and we find more often than not that when there's compromise or there's the ability to come to some consensus on a design or on a project, that works out better for everyone. I can't say that every project is able to be 100% what everybody wants, but to try to drive the project towards something that's a little more agreeable tends to be the way that projects are more successful.
What have you been hearing lately in these neighborhood meetings from a perspective what the neighborhoods are looking for? Obviously, we hear different things, but if someone's looking at a project and they're trying to consider the main concerns of the neighborhoods, what are those right now?
Yeah, so I mean, neighborhoods, as Boston is pretty diverse, the neighborhood needs are diverse as well. I think you'll see, if you go to South Boston versus, Allston, Brighton, you may see different types of needs or what, particular neighborhood groups focus on. I find that, pretty much across the board in the city of Boston, it's no big secret. Certain neighborhoods are very specific about the parking requirement. Off-street parking tends to be something that is always an issue, no matter where you are in the city. But there's some new ways of thinking about how we approach parking. I think that, projects that are close to public transportation nodes, including, train stations or, pretty reliable bus lines, don't necessarily require the level of parking that you might see in more distant neighborhoods. And I know that's sometimes a hard pill to swallow in neighborhood community settings, because everybody seems to be struggling with the issue of off-street parking. But there is a strong desire. A lot of my practice as well is real estate conveyancing. We represent a lot of purchasers and sellers and developers in their projects. And we are seeing more and more in the market people who are looking to have carless households, including people who may want to work downtown but live close to public transportation. And it makes a lot of sense. There are a lot of good amenities in Boston that are pretty accessible to public transportation. So we try to advocate for good planning. We always remind the neighborhood that we're not building for the last 30 years. We're building for the next 100 years. And where transportation will be is another conversation. But we think that the responsible way to approach this is to not build all this space out for parking that may never be used or needed, especially where good, reliable public transportation exists.
Nice. So let's get a little more into the nitty gritty. So if someone's looking at an opportunity or a property that's in a 1F zone or a 2F zone, or the different zones that they can see, kind of explain, what does that mean? Does that mean I can only build a single, or does that mean that there's opportunity there, but how does that all work?
Yeah, so that's a good jumping off point. I mean, the city divides up neighborhoods into, as you describe them, zones, and there's designations in every neighborhood throughout the city. When you refer to 1F, typically that's telling you the maximum number of dwelling units on a single lot is limited to one family. When you say 3F, that's maximum number of units is 3. But there are a number of zones as well that talk about MFR multifamily, as well as just commercial and industrial. So it all just depends on the neighborhood. One of the things that we see a lot more of, is when opportunity presents itself. You look at a neighborhood, you look at neighborhood context. You may come across a neighborhood that has a lot of multifamilies, 3-4 unit buildings, but the zone is perhaps a 2-family limit. And that's because a lot of times the zoning has changed over the years. Our zoning code in Boston, the major overhaul was, back in the 50s and 60s. But we have neighborhood zoning in pretty much every particular neighborhood, where it was probably in the 80s or 90s when the last time the zoning was updated. So what you find is there are instances in which a proposed use may not conform with the zoning code, but it's consistent with the way the neighborhood's developed. In those instances, you would require relief if you're going to propose something, for example, more than a 2-family in a 2F zone. But you would look at it from the perspective of what else exists around here, and is there a reasonable proposal to make that will be consistent with the fabric of that particular neighborhood. And that's not to say that that's a guaranteed use for that site, if just because next door may be a 3-family or a 4-family, but at least it gives you some idea of what the neighborhood looks like and how it feels. I think if you're going to propose a 6-unit building or a 10-unit building in a neighborhood that's just loaded with 1-families, that probably wouldn't make a lot of sense from a planning standpoint. That doesn't mean there's not merit to it. Everything sort of has a case-by-case analysis, and that's an important distinction that the zoning board makes when they review cases. There is no precedent. If the zoning board were to grant a variance for a building on a street with all 1-families to allow somebody to build a 4-family, that doesn't mean the next person that comes along will absolutely get that relief. Every case is looked at on a case-by-case basis.
So one question that I always feel like I'm confused with, and I think others are, is like, if it's say a 2F 2000 and I have a 4,000 square foot lot, does that mean I get to build 4 units?
So hypothetically, a 2F 2000 that you reference is a 2-family maximum with a minimum lot size of 2,000 square feet. If you have a lot that's 4,000 square feet, conceivably you could subdivide that lot into 2 separate lots, because remember, the maximum number of units would be 2-family on any individual lot. The concept of subdivision is a little more complicated. You'd have to meet all of the requirements for the lot dimensions, but if you were able to do that, you could come up with a plan where the lot becomes divided and you have 2 separate lots that two families could be built on it, probably without zoning relief. So that's something you could consider. A lot of times you run into, somebody has a lot that's 5,000 square feet, but they're in a district that, the minimum lot size is 4,000 square feet. And they say, well, I have more space than what the minimum lot size is. You have to remember, in order to divide that lot up, you have to have the minimum amount of square feet for each lot that you're proposing. So a lot of times it doesn't make a lot of sense to take a 5,000 square foot lot and cut into 2 smaller lots. My experience, and again, they're not bound by precedent, my experience, the board frowns upon creating what we call non-conforming lots. They at least want you to have a lot that meets the dimensional requirements of that particular neighborhood. Again, these are all specified very clearly in the zoning code and the zoning maps. Anyone can go on to the BPDA's website. There's what we call a zoning viewer. You can plug in your address in the city of Boston, and it will come up and tell you what zone you're in, and give you a link to the zoning code for that particular neighborhood.
Yes, that's a great point. Before we get into all these questions, so say someone finds something that they think is an opportunity, and what should be their first step to seeing if it is an opportunity? Would they zoning viewer, reach out to Rich Lynds? How does that process work?
Yes, there are, it depends on the sophistication level. I think, people who are new to this industry or want to start, their career in development, property development, I think whether it's Rich Lynds or some other competent attorney, they should be reaching out to somebody who is familiar enough with the code and understands it before they put too much money at risk. Oftentimes, people will buy something speculating that they could develop something there based upon what somebody told them. And the truth of the matter is there are a lot of very complicated nuances about the zoning code which could limit the development potential for a particular parcel. If you're a little bit more sophisticated and comfortable with zoning codes and you understand the terminology and you can sort of wade through what the zoning dimensions look like, yeah, you could go on and start out with taking a look at the zoning viewer to get an idea of what's allowed, what the minimum lot size would be, and what some of the other dimensional controls would be for that particular area. But again, that's something that often, would be more advisable to have somebody who's a little more fluent in understanding these issues to be able to walk through the process and say, this is something that would be allowed, or this is something that wouldn't be allowed. And then there's that gray area of, well, what if I go to the zoning board and request relief? There's always, there's always the possibility of looking at that. But again, there's never a guarantee that that's something that could be approved.
Yeah, I think in the world of zoning, experience really speaks. It's the number one thing. It's having the knowledge, or working with someone who has the knowledge to direct you through. Because looking on paper, you're immediately going to say like, "Oh, there's no way. How'd they do that?" So,
Yeah.
But all right, so we're going to run through some of these questions. A bunch of these came in. People, I got a ton of questions coming in. Keep sending in the questions on Instagram, and I'll get to those at the end. But first up, what is the BPDA?
BPDA stands for the Boston Planning and Development Agency. It was formerly referred to as the BRA, the Boston Redevelopment Authority. When Mayor Walsh was elected, one of his first large orders of business was to sort of overhaul the BRA. They rebranded as the BPDA, and that is the city's planning agency. They're responsible for all things pretty much development-wise in the entire city of Boston. If you're going to be involved in a development project in the city, it's very likely that you will have to interact with the BPDA at some point, whether you're going to obtain a variance. Even for a smaller project, you'll go through what's called design review. And then there's larger projects. There's we call Article 80 size projects. If you're proposing a project that proposes to add at least 20,000 square feet or more, you will go through what's called an Article 80 process. Depending on how big the project is, if it's more than 50,000 square feet, that will determine whether or not you're going to go through what's called small project review or large project review. And again, they have a pretty good and knowledgeable staff who understand what the city's mission and objectives are when it comes to planning for the city. And when you go through that process, including the Article 80 process, there's a board that will have to grant its approval before you can go any further along in the process. And so when you're looking at sort of more aggressive and involved projects, 20,000 square feet or more, there is a parallel process as well as the zoning process that would involve the BPDA's guidance. Unlike projects that are smaller than 20,000 square feet, you are more likely to interact with the BPDA early on in your process, especially when you're doing these larger projects. You'll work with the urban design department as well as a project manager who will help guide you through all of the issues that would need to be addressed as part of your development plan.
So you mentioned the 20,000 square feet and then the 50,000 square feet. What is the process for a project that's in small project review, so 20 to 50, and the requirements, and then 50 to 100 or 200 or 300? What is the requirements, and how do people understand those two sides? Because I know I'm dealing with it right now on some of my projects. I'm doing it because people tell me to do it, but I'm building them 48,000, 49,000 square feet because everyone's telling me don't go into large project review. Mm-hmm. But yeah, I don't know why.
Yeah, so that's again, depending upon the level of development, depends on the developer, what level of development experience they have, and certainly the cost. Small project review under 50,000 square feet, is a bit more involved than a regular development project that just goes to the zoning board, but not as involved as large project. Small project review, the threshold is 50,000 square feet, but you don't see a lot of projects at 52,000 square feet in the city of Boston because you are into that next threshold, which has a lot more by way of filings and information that the BPDA requires, as opposed to a small project review that is a very limited amount of information that gets submitted. Oftentimes we may do, for example, a shadow study or a smaller traffic study for a small project review, but you're most likely going to have to do that in larger projects, anything over 50,000 square feet. So just by way of example, the cost of doing a few more thousand square feet over 50,000 sometimes isn't justified with the amount of additional costs that you have to be involved with in process as well. It's not to say that there aren't relatively straightforward large projects, but there is a lot more by way of disciplines that are involved as opposed to the smaller projects. So I think the best, or at least so the common thinking is, if your project can work under 50,000 square feet, and it's not something that, absolutely has to be 60, 70, 80,000 square feet, then going small project is probably a better approach. That doesn't necessarily mean, that it's, it's going to be quicker, or that it's going to, not involve additional information that the BBD may require, but you certainly know that you're not going to be involved in that much more larger process over 50,000 square feet.
Yeah, no, I mean, so that's pretty much the common thing that I've heard is if it's not going to be like 70,000 or more, most of the time people scale it back to 49 or 48 or 45.
Yeah, I mean, there is a bright line as to what constitutes large versus small. Oftentimes, one of the other considerations are that, if you're in the mid 50,000 square foot, by way of original initial design, and your project ends up getting scaled back anyway, you may have already laid out a significant amount of soft cost money for different planning tools that will be required as part of a large project. And you ultimately would be in the small project threshold anyway. So that's something to think about as to, which direction you want to go at that, sort of that sweet spot of 50,000 square feet.
It's actually interesting. I'd like to actually get a list of the items that have been requested for projects like under 100,000 square feet, 150, because you could actually assign a price tag to every item, and then I could say, well, is it worth it, and is my upside worth it? So it'd be kind of interesting, something to have.
Yeah.
All right, one of the questions from earlier we got in was, and everybody keep sending your questions. I'll get to them. I see a bunch coming in. So explain FAR, and what does FAR stand for?
Yeah, FAR is the floor to area ratio. That is a calculation that's made based upon the amount of land that you have to the amount of gross square footage that you're putting in your building. FAR is a measurement for gross floor area, is measured, essentially take the box of the building and the volume of that building and take your floor area and consider that your gross floor area. You calculate that by dividing the total amount of square footage you have for land. So if you have a 3,000 square foot 3,000 square foot of gross floor area on a 4,000 square foot lot, you're looking at a 75% floor area ratio. If you're at 4,000 square feet in a 4,000 square foot lot, you're at 100% FAR. The zoning code specifies just about anywhere in the city that there is a certain FAR limit, and that's the maximum amount of floor space you can have in relationship to the amount of square footage you have for land. If you exceed that, or it's already exceeded, any development will require relief from the Board of Appeals for a variance. So even if you have an existing condition of let's say an existing building that has an FAR of 3, 3 times the floor area, 3 times the square footage of your land, and you were to make a modification to that and add even 10 more square feet, you're already in excess of the floor area ratio that's allowed for that neighborhood, for example. You would have to go for a variance for that. So a lot of times you'll see, especially on renovation projects, unless it's absolutely critical, if it's the only thing you're going to need for relief, a lot of times you won't see any adjustments to the FAR or the floor area. You work within what the existing conditions are. And the zoning code, like most zoning codes throughout the country, would protect existing nonconformities. So if you do exceed the FAR for an existing building, you're free to make modifications to that as long as you're not affecting the FAR, at least in this particular case. And you would not be subject to having to go for relief for that existing non-conforming condition. But you would if you were to change that or add any square footage in those instances.
Yeah, I think one thing it's for newbies out there. I know I almost made this mistake. We had a couple projects when I was getting started where it's like, oh, I'll add stuff to the basement. I got a great basement. I'll just add square footage. And people think it's just like you see like on TV or people building into attics or finishing basements in these TV shows. Oh, I'm just going to do it.
Yeah.
Not in the city of Boston.
Yeah, and it's tough. It's a good point. The city of Boston, my experience is the zoning codes are written in a way to ensure that pretty much anything that's built these days or modified would require potentially some type of zoning relief. And a lot of the zoning codes are older. You know, they've probably taken into account a lot of the buildings that were already pre-existing. Boston being a relatively older city, I think what you find is that when zoning codes get written for a neighborhood, many of the buildings become non-conforming, whether it's height, setback, FAR, lot area, any of those issues. So if you're going to make any change to a building, and that's part of your, you know, consideration in purchasing, again, it probably makes good sense to consult with somebody who knows and understands that that interplay between floor area ratio, existing conditions, proposed conditions, and, you know, any grandfathering of the FAR that may exist.
Yeah, that's one thing for anyone out there. If you are buying a property and you're going to do a project, say it has a finished basement, right? And it's actually finished, not like low ceilings, got 7-8 foot ceilings, you know, it's finished in living space, 2 egresses. Make sure before you demo that, you go through the process with an architect and get that considered as finished space. Because once you rip it out, the architect shows up, it's no longer a finished space, and then you're going through zoning. So, you know, first things first, get an architect onto the job and get that architect to draw an existing conditions plan and stamp it. At least then you have a documented stamped plan that shows what it was before you started.
Yeah, and you save yourself a lot of time and aggravation if you didn't need, you know, if the only thing you're going for is an FAR variance, or you need to go for an FAR variance, and you didn't have to. You saved yourself, you know, legal costs, additional architectural costs, and time. I mean, the time to move through the process right now in the city of Boston, you know, and it's no reflection on, you know, the hardworking people at ISD and the Board of Appeals. It's just a lot of business coming through the city, and they can only get to so many cases at a time. So it does take some time between the community process, the filing for a building permit, and actually getting a variance. It's not like a lot of cities and towns that I've worked in where, you know, you file your application at the beginning of the month and you're on at the end of the month. It doesn't really work that way in the city of Boston. So people should take that into account, that, you know, as the saying goes, time is money. So if you're not prepared to spend that kind of time before you can finish your project, then that's an important consideration early on as to whether or not that's, you know, that's something you should be looking at for by way of zoning relief.
Let's talk about affordable units. How does that process work with affordability?
Sure.
And, you know, I guess, you know, overall, what's the rules on affordability? And then how about, you know, what are the affordable ratios? How many units and that stuff?
Yeah. So the city of Boston has what's called an inclusionary development policy, often referred to as the IDP. IDP in the city right now says that any project that's 10 or more units, new units being proposed that requires zoning relief, must set aside a minimum of 13%. That's the general rule, and then it sort of adjusts elsewhere throughout the city where zoning codes have been updated. But the general rule is 13% of the units have to be set aside for inclusionary development policy type units. And that's administered through the Boston Planning Development Agency and the Department of Neighborhood Development, in which a certain price limit is set, whether it's rental or for sale units, based upon a schedule that the BPDA, you can find on their website. And the way it works is you take the total number of units you're proposing, whatever you end up with for approvals, and 13% of those have to be set aside. It's done through a deed rider. So once your project is completed, the affordability covenants are included in the registry of deeds. And it's something that runs with the land, a minimum of 50 years. And it's a good policy to ensure that as development occurs throughout the city is also being a responsible governmental agency in ensuring that we're adding, or developers are adding to affordable housing opportunities. The way it typically works is, you know, we see it through a lot of the Article 80 small project, large project reviews, because one of the other thresholds for small project review is 15 units or more. If you're adding 15 or more units, you are also subject to small project review under Article 80. That's not to say that there aren't projects where you have 10 or 11 units being proposed and still require zoning relief, but you would be then required to provide the 13% affordable. One of the criticisms that we do hear a lot is that some developers, it just doesn't work on a project of that size to be able to propose an affordable unit. So what they do is they limit the number of units to 9, and that has invited some sometimes fair criticism of people say that that's an opportunity to avoid having to provide affordable units. I sort of take a different view on that. If you're proposing, the bright line is 10 units. If you're proposing 10 or more units, then you're subject to the IDB policy. If you're not, then you're not. And it's just really the way it's worked. I know there's been some opportunities out there to look at, 9-unit projects where maybe one of the units can be proposed as coming under the IDP policy as sort of a trade-off through the community process. I think we'll see more of that soon. I think that there's definitely opportunities for, where a project might be met with some resistance to at least voluntarily offer an IDP unit. That remains to be seen how that's going to be received, but there are, I think, opportunities out there for that to happen. Interestingly enough, the process moves pretty smoothly, depending on whether it's a condo project where the units are for sale or it's a rental project. Everything's done by lottery. There's minimum qualifications and requirements that's handled through the city of Boston. And there's a pool of purchasers or renters who would like to occupy one or purchase one of these affordable units. And based upon the vetting that's done by the city, depending upon who can ultimately be determined as qualified, they would go through that lottery process, and if they're successful, either be able to rent one of these affordable units that get built or purchase them to own.
So how does it work if the math comes in and it's like, I do 13% and I'm at 2.4?
Yeah.
Do I have to do a half of an affordable, or do I get to go backwards or round up, round down?
Yeah. So up to 2.49, you would round down for the number of units, but you then have to buy out. So the general rule is $200,000 is the buyout for an affordable unit, and that has to be addressed with the BPDA and the city. But the way it would work is if you were at, your ratio comes to 2.46, you would be required to do 2 units, and then 46% of $200,000 would be paid into the inclusionary development fund to help support additional affordable housing in the city. If you're over the 0.5, so it's 2.54, then you round up and you're required to provide the 3 units. There are opportunities to, and again, it's a little bit more involved probably for this discussion, but there are opportunities to buy out of the affordable program. But again, that's something that has to be approved by the city and typically done in advance. It's not something you would do on the fly after your project's ready and the numbers aren't working necessarily. It has to be set forth in advance. And there are other opportunities where you can do off-site affordable housing, especially for larger projects. But again, that involves very early conversations and discussions with the planning department and the city of Boston to ensure that that's something that meets the objectives for that particular project. I think the preference is to have the affordable units located on site for a lot of these projects. They don't necessarily prefer to have them located somewhere else simply for the sake of making the project more profitable. It's the mission of this policy is to provide affordable units within new projects that are being built throughout the city.
Nice. So this question comes in from our good friend Joe. Head houses versus hatches.
Yeah, good one. Again, neighborhood. So yeah, head house and hatches for those not entirely familiar with that. Roof decks are a great opportunity for additional outdoor space on projects. The idea is that you are taking a space that's otherwise underutilized and creating a nice amenity for a building, whether it's a common roof deck or a roof deck that that will be used exclusively. But the idea is that when you want to access that roof deck, how do you do it? There are 2 options. One would be the head house, which is a full stairwell, and you probably can describe it better, Ricky. It's a full stairwell that walks out onto a deck with full height and a structure that's protecting that stairwell, versus the hatch that sort of opens up probably from the inside of a unit or a hallway or some other access point that allows you to go out onto the deck and doesn't require a structure to protrude above above the roof line. My experience is that it just, again, depends on the neighborhood and depends on what's actually happening by way of context in that neighborhood. Certain neighborhoods don't necessarily like head houses. They feel that it's, you know, it's an added eyesore, if you will, in certain buildings, especially if they're visible from the street. So head houses oftentimes will be frowned upon. But then there's sort of this other separate issue that you're dealing with right now where, you know, a building at a certain height may not be permitted to have a hatch, but to access a roof deck, and therefore your only option if you want to have a roof deck is to have the head house. There's a little bit more of a complexity that goes along with that, and that involves whether or not the building code would permit a hatch at a certain height. But those are all issues that you can certainly work through if you decide that's the direction you want to go. I think the driving force a lot of times is going to be what the neighborhood's preference is. Neighborhoods that don't like head houses, and if there's no other way around it, you may have to forego the roof deck as part of the project if they won't support a project with a head house. So that's something to consider when you're going through that process.
Got a question in. How long do ZBA or BPDA approvals stay valid?
Good question. So as I mentioned earlier in the conversation, Boston has its own unique zoning code. The rest of the Commonwealth of Massachusetts is governed by Chapter 40A, which is known as the Zoning Act. Under Chapter 40A, and this comes up a lot when we deal with people who have not really dealt with Boston. Pretty much everywhere else, zoning decisions are good for 1 year. In Boston, they're good for 2. And the reason and the rationale, I guess, is because of the amount and volume of decisions that we have and the time it takes actually to go from the zoning decision to permit. But it's something that's been codified for some time, so that the 2-year limit from the time that it's filed with the Inspectional Services Department is your time limit. Now, you are entitled, just like you are anywhere else in the Commonwealth, to request an extension of your decision. And that it's advisable that if you have gotten a decision and it's been almost 2 years, that you get your request in before it expires. It really is advisable to make sure that you get your request in and have it heard before the actual 2 years elapse, so that you don't let your zoning relief run out. There's no, again, it's up to the board entirely. The board has to vote on that, and the board, in its discretion, could deny an extension. Oftentimes, they like to know why an extension is necessary, and whether it's financing or, you know, finalizing the permit process, et cetera. Those are reasons that the board will probably want to hear. BPDA approval is a little different. A BPDA approval is not necessarily statutory like a zoning approval is, but the BPDA has discretion as to whether or not to allow decisions or their approvals to go on forever. Oftentimes, if a decision has been rendered and activity has not happened with a particular project, the BPDA may want an update. They may want you to go out and talk to the neighborhood before you go ahead and start, you know, finalizing your permits, especially if it's been quite some time since the approvals occurred. They prefer to see projects move forward, especially when they've granted approvals, but don't necessarily have a specific drop-dead expiration date on them. It's really tied more to the zoning decision, which is limited to 2 years.
Hey, Rich, I want to do a condo conversion. Is this a zoning process?
The question comes up a lot. So condominium is state law. Condominium conversion is state law. It's Chapter 183A. And all a condominium is a form of ownership. Condominiums are established by recording a master deed with the Registry of Deeds and dividing the property up into individual units. In Boston, there is no specific condominium conversion requirement. That's not like other municipalities. Certain municipalities, such as Somerville, have a very specific process for getting your condominium approved. That doesn't exist in Boston. There are, again, you should consult with somebody if you're proposing to do a project like that. But in Boston, for example, there is no specific requirement. If your occupancy for your building is a 5-unit building, then you are permitted to go ahead and file a master deed for a 5-unit condominium project. there isn't any special relief necessary unless you're doing work that we talked about previously that either increases floor space, changes the building, or modifies the building. That's going to trigger some particular zoning violation. But there isn't a specific requirement to get zoning approval to convert a building to condos in Boston. I would point out there are a number of other issues that go along with condominium conversions, including rights of tenants. For example, if you have a building that's more than 3 units, if there are elderly people living in the building at the time you're proposing conversion, there are a whole host of issues that could arise. So those are things that you should check in as part of your due diligence if you're proposing to do a condo project pretty much anywhere in the state.
Yeah, I think, make sure, Boston's its own place. If you're doing a project, I always tell everyone who watches or listens, if you're not in Boston, be very careful thinking you're just going to split a building into multiple condos. Oh. Biggest mistake or most common mistake you see from someone or a newbie getting into the world of development?
I wouldn't say it's the most common, but it's one that I think takes people by surprise. Oftentimes, we're engaged after an offer has been accepted on a property, usually to negotiate the purchase agreement, then handle the development. A lot of times, they will craft their own contingency as to allowing them enough time to go through the zoning process. And we've seen multiple times where people are not familiar with the process in Boston. Go ahead and agree to a 90-day closing date, assuming that they would have all their approvals in place within that time period. And then, unfortunately, we break the bad news that it's very unrealistic to think that you'd be done in 90 days. So that's probably one that I would say, be wary of if you're making an offer on a property that's going, you're going to be going through the zoning process. You need a very, very specific zoning contingency that allows you enough time to get through the process, obviously while pursuing approvals diligently, but you want to ensure that you're not cutting yourself short so that you're going to be held to a closing even though you have not been able to get your approvals within the time period that you made the offer for.
Yeah, I mean, I think, you nowadays, for anyone watching, you should be going for at least 12 months with the option to purchase or extend, at least 1 to 3 additional times to be safe. I mean, things just get delayed. Neighborhoods ask for more meetings. And then even when you finish the process, you go to sign up for the ZBA and then they're booked out 3 months. And you're at that point, if you're going to the seller and you're saying, I'm waiting for my ZBA date, if your offer and your P&S is not drafted properly, they can tell you to kick rocks or close. And then everything you did is just gone. So when someone's trying to negotiate on you and won't give you a proper zoning contingency, be very careful when you make the decision to agree without the ability to do extensions, because we've all seen it. I've heard horror stories. Luckily, we've gotten out of most of mine. Rich and I have had a few where we've begged and cried. But it's like, be careful about the timeline and make sure you add in a couple of additional extensions and say, hey, we'll be done in 9 months, but I need the right to buy or extend 2 months, 3 times for 2 months if I have to. I won't, but if I have to.
Yeah, and oftentimes, again, because a lot of this process and the mechanics behind this process are out of the control of the purchaser or the developer, is that, we say, if we have been diligently pursuing approvals, including just waiting for a zoning board date, which is not set by the developer or the purchaser, it's set by the city, then we sort of have a kick out that allows for an automatic extension, meaning you can't get the rug pulled off underneath you just because you're waiting for your hearing. So what we try to do is be fair about how we're approaching this from a seller, but often we find that where a seller is understanding the buyer's purchasing it for development purposes, they're obviously getting a premium price for the project. They need to understand the premium price only applies if the approvals occur. So that's not something that should be lost on a lot of sellers, especially if they're sophisticated in the marketplace. I do find that you have a lot of sellers out there that say, hey, the gold rush is coming, I want to get in on it, where's my payday, and I want to close in 60 days. Like, doesn't work that way. I think a lot of sellers are learning that the process has to occur before you can actually add the value. So be wary of that, especially when you're making offers for development type projects, development type properties.
Yeah, I think one thing we really approach it is we say we're a team here. I'm trying to make your property worth significantly more than it's worth right now. And so we're working on this together. So don't try to set a timeline to then walk away, because that's not the overall concept here. The concept is I'm working for you to make your house worth more money.
Yeah.
So we got some questions that came in. We'll bang out a couple of these questions. Let's see here. Yeah, this is right there. First one. I mean, describe an offer that's subject to, and what do you typically close on the subject? When do you typically close on the subject property?
Yeah, so I mean, language typically would look something like, the buyer's obligations are specifically and expressly contingent upon obtaining all necessary approvals for the intended project. Sellers don't like that. It's a little open-ended. So you do is you'd put a date in there to say, but no later than X date, and then you add a couple of qualifiers in there as well that says, provided I'm diligently pursuing these approvals, I should have the ability to extend reasonably to get this concluded. Clearly, if a buyer is not, is just dragging their feet and not doing what they're supposed to be doing, they're not going to get the benefit of having that extra time. But it creates a fair agreement between the parties where, as Ricky said, you're partners in this. I mean, the risk that the buyer has is the cost and expense they're going through to get this done. The risk the seller has is the property's off the market for a certain period of time. But there's an intersection there of mutual benefit that everybody will ultimately experience if the project gets approved and the deal closes. But everybody's got to sort of come to the table with the same expectations, and to say that we're going to cut this off at a certain point regardless of where you are isn't really fair for the buyer. So I think adding those in, and I find most of the attorneys that practice and are familiar with the Boston process respect that contingency. They understand how it works, and we usually don't have an issue getting that negotiated into a purchase agreement. I do find that when you're dealing with a seller that doesn't have a lot of experience in the way this process works, it's a little bit more of a learning curve. But if it's spelled out by somebody who's pretty experienced in this area, then it should be able to be included in that type of an agreement.
John BN123 is a great question. With deed restrictions, say they've been in place for 27 years and they're set to expire in 3 years. How do you go about proposing a project or proposing different things to that neighborhood development? I think this is actually something that's coming up a lot, because there's a lot of land I know in Dorchester that was sold off by the city with deed restrictions 30 years ago or 27 years ago. So you're going to start seeing a lot of these. How does that work? Yeah,
I have a little experience with this. So there was a case back in, dating myself here, my office argued before the land court involving the Massport Authority. Massport had sold off about maybe 50 parcels of land in East Boston years ago, back in the 70s. And when they sold the land off, they included language in the deeds that said that the land could never be built on, couldn't be used for to construct a structure forever. I mean, they didn't put any time limit on it. And a particular client had purchased that land with the intentions to develop on it, and lo and behold, got a letter from Massport saying you can't build on it. It's restricted. So they retained our office. We went to land court to battle the restrictions, because there is a statute in Massachusetts that says restrictions that prohibit this type of activity on the land that are unlimited as to time expire after 30 years unless they're extended appropriately. There are a number of exceptions. I don't want to just give a general blanket statement on this. There are exceptions to that rule, but generally where restrictions are imposed that don't meet any of those other exceptions to the rule, they would expire after 30 years if they're not carried forward. So there's I would say a treasure trove of potential developable parcels if somebody had the ability to go through the process of trying to find some of these expiring restrictions, I would say, and potentially try to acquire them for development purposes. They may be ripe for development at some point in the near future. Pretty much all of the Massport parcels that were sold in the 70s, and my office has been involved with developing a number of them. Those are all expired, so those are available for development, obviously subject to zoning, but there's no further restriction on the land that would prevent them from being built on.
Jeff Gannon, great architect that you and I have worked with over the years, asks, can you list in priority your top 3 concerns of variances when you're working with a neighborhood?
I think it just depends. It's neighborhood to neighborhood. I mean, I'll use where I practice a lot, East Boston. It actually even can be more specific within a neighborhood. Certain neighborhoods have bigger priorities than others. I think what you find, and again, I'll use East Boston as an example. Places like Eagle Hill, parking tends to be a big issue. Not the least of which is because it's probably the most remote for many train stations. If you think of streets such as Condor Street or White Street, it's a pretty good walk to a train station. So parking tends to be important for development projects. But if you were to go to, and I'm not trying to belittle any particular neighborhood as to what their concerns might be, but I find that places like Jeffreys Point or closer to Maverick Square don't tend to think parking is the biggest issue. I'm not saying it's not an issue, but it's not as important when you go to a place like Eagle Hill. And I think that's a common theme throughout the city. I think depending upon where you go and what neighborhood, they all may have different concerns. I think height, density, all of those are going to be consistent issues throughout the city. But I think for the most part, I find that parking tends to be probably right at the top of the list, depending upon what you're proposing. And I think that a lot of that has to do with how projects are being proposed these days. They're not, a 1-to-1 parking ratio is not something that we see a lot of. And people always ask, well, if you build a project with 12 units or 14 units and you're only proposing 9 parking spaces, how does that work? It's interesting to see how it works, because I think that people who absolutely need parking, if they're buying a condo and they understand that parking is not available, well, that's not likely to be within their wheelhouse of potential targets for them to go and look at and purchase. And I think that it's worked out. The market has sort of sorted a lot of this out. People are not excited about on-street parking and really want off-street parking, and there isn't any available for a particular project that's being proposed, and that's something that will limit the market of or available people that will be looking to purchase at a place like that. Again, I think it varies by neighborhood to neighborhood. I think height is always a concern, especially depending on the context of the area. But there are plenty of areas that we see throughout the city that height is a lot more tolerated. I think when you look at your larger boulevards or squares or areas that really are in need of development, I think height becomes less of a concern, and certainly the types of uses that that are being proposed will also be considered important.
Yeah, I think that this falls right into that. Jack Ordway asks, what section of the city are you seeing is most favorable for zoning allowances for developers? I think you hit it right on the head with the main corridors. It's kind of the main talk right now, but
yeah,
kind of elaborate on that.
Yeah, I don't know. I mean, it's hard to say, because I don't think there's any, like, the city doesn't approach this by saying this particular neighborhood are going to be very flexible. The zoning board takes, every one of these cases on a case-by-case basis. We have a lot of new members on the zoning board that, there's members that have been on the board for a long time, certainly as long as I've been practicing. And I think that we are seeing, a very thoughtful and detailed approach that the zoning board has taken these days to projects, and they really consider the context of particular neighborhoods, what the planning objectives are for those neighborhoods, if there's any current planning studies going on, and then of course the input from surrounding residents as to what their feelings are. I think project proponents and developers do themselves a huge favor by getting early outreach to neighbors and not having neighbors react to this.
We're back. Looks like we lost Rich. Hopefully you guys can join back in and we can get him on for these final few questions.
I don't know what happened there. I was mid-sentence.
No,
yeah, like I was saying, I think going door to door early on in the process makes a huge difference in not only informing neighborhood stakeholders in what you're proposing, but getting early buy-in for their comments so that you're not spending a lot of time changing your project around based upon what the community group's reaction may be to it. So I think that regardless of what neighborhood you're working in, that makes a big difference in the success of a project.
I saw Peter asked a question earlier. We lost it in the comments, but I'm buying a project that's zoning approved, right? What are some concerns that they should have that zoning approval is going to continue forward to a good project and be something that they can build?
Yeah, I mean, buying zoning approved projects, is probably, the one area that, I could strongly recommend don't go it alone. That's one where you want a very competent professional reviewing the decision to know what you're purchasing, because believe it or not, there are times and instances where, if you got a zoning decision, you think, oh, this is what I can build, and come to find out that there's some defect with that decision, or, the decision, as we talked about earlier, may be expired. There may be additional steps that you're required to take. So, in doing that, I certainly recommend hiring a professional to review that and to ensure that what you're looking to buy is exactly what you're getting. Assuming that all occurs, zoning decisions run with the land. It doesn't necessarily expire on a sale or transfer. So, if Mrs. Smith obtained approvals and you were purchasing those approvals, you would do that, and simply assume the responsibility after you became the owner of completing the project. There's certain things that one would want to check on to ensure that there are no appeals that have been filed against the decision. The decision is valid, and certainly all of the relief that would be requested or required has been granted.
Question came in from Chris. Once COVID clears, will the city expedite the approval process to get projects going again? We had a couple of questions about this, and have we heard any talk about additional ZBA meetings every week? Additional neighborhood meetings, like things to restart the real estate economy.
Yeah, I'm sure, as in case not everybody's aware of this, I mean, when the city put the stay-at-home order in place, pretty much throughout the Commonwealth, everything pretty much came to a halt, including construction projects throughout the city. There's exceptions that allow for, I think, smaller projects to continue, but any of the larger projects are pretty much on hold. They can't go back to working without putting in place a COVID-19 safety plan. That's something that would be done with inspectional service. And I think the city is trying to be thoughtful about how to get construction working again before they start getting into issuing new permits and new approvals. The zoning board canceled all of its meetings since the middle of March. We're just informed that the first meeting in May is canceled as well, which would have been, I believe, it was either tomorrow or next Tuesday. There is another meeting scheduled for May 19th, knowing that the governor is indicating that the stay-at-home order will be in effect until at least May 18th. I'm not sure how they're going to approach May 19th zoning board hearing. We've reached out to the administrative staff just to find out, because we have hearings on that day. We want to make sure we're ready. But depending upon what they decide to do, whether they go remote or cancel the hearing again, that'll push things back. That creates a separate concern, certainly from buyers and developers and practitioners. The backlog of cases is going to be somewhat of a concern here, because the zoning board only meets right now every 2 weeks. They probably hear cases from 9:30 in the morning till 1, 2 in the afternoon sometimes. There may be 30 to 40 cases on a regular agenda you have to figure that all of the backlog of cases now all have to be figured out. So I'm not really sure what their plan is. Hopefully, they're having discussions about that to try to address it. The secondary concern is, when we talked about earlier, was the community process that that has to be undertaken in order to get these projects moved forward. Our pipeline continues to be processed with the city. The city is accepting permit applications. They are issuing refusal letters. They are processing appeals, but we're not out there presenting them and moving these through the process. So that backlog is also building, and I'm not really sure at this point what the solution will be. But my concern is it's going to get very busy, both at the zoning board as well as through all these community meetings once this clears a bit.
Yeah. Well, everybody, we lost some questions during that technical difficulty, but if we didn't get into your questions, feel free to send them over to Rich, or you can send them to me directly. If I can answer them, I'm happy to send some answers. Not an attorney, but I'll give you some input. If not, I can, send them to Rich for some answers on them. If you missed this interview, we always record them, and then we'll put them up on our YouTube so you can watch it back. If you missed something you want to see, you can go on there. But Rich, thanks for joining us. This has been awesome. I think extremely informative. But you have any final words?
No, thanks for having me. This is great. Happy to come back and do it again another time if you think it's worthwhile. And just hope everybody stays safe out there. And hopefully we get through this sooner rather than later.
Great. Thanks, Rich. Talk to you soon.
Thanks. Have a good night.
Bye.
Bye.